Reporters Roundtable provides viewers with in-depth examination of issues reported on leading media outlets across the world. A lively panel of journalists with comprehensive knowledge in all fields of endeavor, be it politics, health, business, sports, entertainment, information, communication technology, gender, law, international affairs and diplomacy, and a host of others will objectively dissect the matter of contention. On Reporters Roundtable, fairness, objectivity, factuality, and non-partisanship is our hallmark. It's the Double RT Show with Rebecca Ewa. This and every other Thursday from 10 to 12 GMT. Make a date with us. The Reporters Roundtable, all angles, all sides. Welcome to another edition of the Reporters Roundtable. My name is Rebecca Ewa. Now, the run-up to the December election has been characterized by one challenge or the other, with legal suits following the disqualification of some presidential aspirants. The embattled candidates have sued the Electoral Commission, with some individuals also seeking the courts to rule on whether or not ballots cast during special voting should be counted immediately after voting. Against this background, Supreme Court Judge Justice Jones Doche has urged political parties to accept decisions of the court on electoral disputes that may arise from the general election. A former director of Ghana's Electoral Commission, Kwame Damwa, has also expressed worry over the continuous legal battles against the commission, indicating it could affect the credibility of the December 7 elections. Some have called on the Electoral Commission to allow for a peaceful process and educate the candidates for subsequent elections so as not to repeat such mistakes. There is another school of thought that building a strong institution is the way to go and the time to start is now. But how about the timing for this hullabaloo? Is it right or wrong? And what happens should the court grant the injunction being sought by the parties? Would that mean that the December 7 election will have to be delayed? And for how long? Will we even get to that wit end? This is what we are discussing on the Reporters Roundtable, and to help me do this is Osei Bonsu Dixon. He is a lawyer, an activist, a legal academic, and the national president of the Business Law Society of Ghana. Colleague journalist and host of Moment Tonight is here in the studio, Abdul Hai Mumin, and will be joined later by Gloria Anderson of Radio Ghana. Welcome, gentlemen.
Thank you very much.
Thank you.
Let me start with you, lawyer. Where we have gotten to,
Right.
just give us a spotlight. What is the nature of the case in the first place? What is it all about?
Well, I think it's basically to do with the contest over the decisions that the electoral commissioner has made. The electoral commissioner has disqualified a number of the applicants for presidential candidature, and these persons who are affected are pursuing remedies for the court. I mean, as I understand it, some of them tried to speak or to talk to the Electoral Commission out of it. It didn't work. So largely what you have is a flurry of lawsuits now in the courts, and that's something probably maybe we could get into. But the nature of what is in court is that the parties tend to disagree. They disagree on the interpretation the Electoral Commission has given to his own rules, and for the fact that they do not have an opportunity to get any kind of remedy, rectification of whatever problems actually is with their, their filing papers and the like. If you pick, for instance, the PPP, I mean, they are very topical in this kind of discussion. I mean, they look at the CI 94 and Section 9, for instance. I mean, their basic beef is that they should have some corrective application from the Electoral Commissioner if it looks at the nature of that sub-regulation 9. That allows them to file, and if there are irregularities or there are difficulties for the subscribers and so on and so forth, the Electoral Commission will call them and give them a period to rectify or to correct. They think they haven't gotten it. The EC, on the other hand, also thinks that if parties have filed very late and have filed or misfiled, and that they've been caught by the rules. And so if you are caught by the rules, you have to be sidestepped and allow those who have duly fill those forms and have valid candidature run the election, not persons who, through either some negligence on their own part or failure one way or the other, have contributed to their own woes. And so our Electoral Commission has dared them. You can go ahead and sue. I remember I heard this said about Nana Kunadu Ajumai Rawlings' party. You understand that if you have beef, you have issues with these things, go ahead, file a lawsuit.
Okay. Abdul, following the news, would you say that where we are now, we should have come to this point? Couldn't there have been other measures we could have sought other than going to the law courts?
Let me start by saying that I'm just an ordinary journalist. I do not have the kind of qualifications that Lawyer Dixon does have when it comes to law, and therefore I do not have the kind of knowledge that he has, especially when it comes to
in your field.
Yeah, but exactly the point. Exactly the point I'm coming to. So I will not attempt to look at issues from the legal point of view, and thankfully we are on the reporters round table, and therefore I'll speak merely as a reporter, and a reporter who has been around, was actively involved in covering the 24 election, 28 elections, and after the 2012 elections, I was at the center of the live coverage of the election petition in 2013. So to that extent, I know quite a bit about the political terrain and what has been going on with regards to, the legal arena as well. And to come to your question, which has got to do with whether or not we should have come to where we are in the first place, I would say, why not? We have chosen to take a certain path, a path known as democracy. And that democratic space allows for people who feel aggrieved to use certain measures to address their grievances. And to the extent that we have given people that opportunity, we should have no qualms at all when people begin to use the opportunities that the democratic space has opened for them. And so I just think that we are growing. Usually when issues come up, we are quick to refer to the United States of America. We are quick to refer to the Western world and say, even in the Western world, this is how they do their things. But I believe that they started from a certain point, And today, even as we speak, their system is still not perfect. If you follow the events in the US currently between Trump and Hillary Clinton, you realize that even the US democracy still has some loopholes they need to fill. We have just started. Our democracy is just about 22, 23 years old. And so we are pretty much a very young democracy. And until and unless these loopholes are found and the loopholes closed, we cannot have a perfect system. And so if you ask me as a reporter, I'm happy that these things are coming up, especially at this time, because it then gives us the chance to test, first of all, the legal processes, our electoral processes. There was a Constitution Review Commission, which I'm sure that people like you and I ordinarily covered without taking a keen interest in the issues that are affected us as reporters and the generality of the Ghanaian populace. We took those things for granted. Today, it has come to bear that, look, why didn't anybody see that there would have been the necessity for people to get up when they are aggrieved, especially looking at the time between elections and the time allotted for the swearing in of a new president. You are aware that on the 6th of January, Parliament is supposed to be dissolved. You are aware that on the 7th of January, the new president, whoever it is supposed to be sworn in. These are unchangeable per our constitution. Why didn't anybody foresee that between 7th January and 7th December and 7th January, that space is too little for anything significant to be done? Time after 2008 should have taught us a huge lesson. We're all not paying attention. Time happened on the 28th of December. Assuming that it wasn't only time and that with that the re-election had to be done in several other districts, could we have withstood the kind of pressure? We were not paying attention. I think this is a wake-up call for all of us. And if you ask me, I have no qualms at all that people are going the legal way.
Yeah. But lawyer, could this have been avoided?
Okay, on the heels of
looking
what?
at the timing, as Abdul have made mention of.
Could it have been avoided?
Yeah.
No, but you know what, Becky? I mean, I think there are a couple of things that we need to bear in mind, and I mean, thoroughly agree with him. We cannot, in the first place, foresee every eventuality. We have already made known the rules of the game. And so when the rules of the games are being applied, I don't think that as a people we ought to actually cry foul about it. Perhaps we will be concerned. That is normal. After all, we are about 40 or so plus days towards 40-something days or something towards elections. And so we will naturally would have some kind of worry if these tussles come. But they can come even in the, in a week before we cast our votes. That is something that we must. There is no, there are no outside provisions that say that you cannot do this or do that 60 days or 30 days or 2 days or 1 minute, even to, for instance, the count of the votes or the exercise of adult suffrage. So what people are doing, the first important thing I want us to understand is that the rules of the game accommodate this. It was foreseen long ago, as far back as 1992, that we might have issues like this. And that is the reason why these things were embedded first in our national constitution and throughout the various CIs that we have had. But back to your point, is it possible it could have been averted? My answer would be that possibly it could be. Because if you look at the nature of even the CI itself, it's written in a certain form of to allow for smaller.
Educate us on the CI 90.
Which
is the
well, very good.
Educate us.
Yes,
so that
it's first. The 91 largely looks at registration of voters. The 94 is about the aspirants themselves and those who contest the election. You understand? And I think because of time and all those things, the most essential provisions I want to actually hit on has to do with those that allow for persons to file. It allows for presidential aspirants and persons who are in this field who are going to file for parliamentary, presidential, all those kinds of the actors. It provides rules about how they should do it. And the electoral commissioner is situated in all this and as a major actor. Now, part of the enactment permits them to submit and the EC to vet it. And if there are problems, to throw it back at them, telling them maybe this way or that way. If they do not comply, the EC has powers of disqualification, which, for instance, in the current circumstance, we have seen. So that, in a nutshell, is something I just want to actually lay down. There are, if you look at that, I want us to situate it within a broader spread of laws, not law, but laws. Because we do have, for instance, the ADR Act of 2010. You understand? And that ADR Act, I think Section 7 and Section 12.
When you say ADR, what do
I'm talking about alternative dispute resolution.
Right.
I'm sorry, alternative dispute resolution. That this country itself has resolved. There are various ways of accommodating disputes. Disputes are bound to occur. You can use litigation, which means you go to court. Or you can use, for instance, mediation. You can use conciliation. You can use arbitration. You can use negotiation. All these forms avail. And if the parties, for instance, are willing to sit down in dialogue, they can apply these things. They can go to court and ask for an out-of-court settlement, so that they can sit down and then talk and dialogue, and then have the court adapt whatever conclusions that they have validly reached. That is permissible. And so a courtroom is not only a place for a judge making declarations about certain issues. It's also for the parties themselves. It's a right forum for them to think about the nature of their dispute, the length of it, the nuances of it, and to see whether it's amenable to a dialogue and all those things.
Now, for instance, resolution.
Perfect.
But let me. I'll come back.
But let me end on that point.
Great.
For instance, the Business Law Society of Ghana, for instance, threw in the issue that look, it's not all lost. It is good they've gone to court. Fine, they have. They are exercising their legal rights. But whilst in court, looking at the time and all those kinds of things, dialogue and informed dialogue can help. And so that issue is still available, you understand. But then, well, let's leave these matters because the courts have jurisdiction over the matters and we'll deal with them.
We do not want to go into the merits of the case itself because that will be found.
We're not getting prejudice.
Found for contempt. Right. That we will not attempt to do. But what I want to find out from Abdul is, lawyer has made a point of ADR, and as a reporter, as a journalist, looking at the posture or the position of the parties involved, do you foresee that even from the scratch, they would have resorted to dialogue? Because it looks as if most of the parties have taken an entrenched position.
Again, when you go back to watch the tape that shows the electoral commissioner, the chairman, making the announcements about those presidential aspirants who did not qualify per the EC's own criteria, you would realize that there were parts that she impugned criminality on the part of some of those presidential aspirants, and she proceeded to say the matter would be referred to the Attorney General as well as to the police. And lawyer is here, maybe we would need some education when it comes to criminal issues. Then you don't have alternative dispute resolution. From my layman's point of view, I understand that alternative dispute resolution mostly has to do with civil issues and not criminal matters. Maybe we need some education on that as we proceed. But if what I know is anything to go by, then from the onset, there was no room at all for alternative dispute resolution except for the parties to go to court. And I think that, and I'm forgive me if I'm wrong, but I think I heard the Electoral Commission chairman also indicate that persons who were not satisfied or who had grievances were free to go to court. And so from the onset, the grounds had been prepared only for the courts to deal with the matter, and look at the issue of ADR had no place at all whatsoever. I could be wrong again because I don't have the legal education on this matter. So
maybe I can highlight on that one. I think maybe she's raising the issues about the criminality and all those ones. It's possible that because of that, it might nab the issues about an alternate dispute resolution. But even in various matters that we have, you can sequestrate them. You can look at the criminal aspect of something in terms of persons who have willingly or knowingly committed a criminal violation. And then look at the civil aspects of issues. If somebody, for instance, hits you, tears your dress, yes, assault can lie, criminal assault can lie, but at the same time, there are also civil aspects of it regarding your dress, compensation for it, and all those ones. And my reading, like I said, of this permits, at least if you find how do you call it? Like for instance, I mean, somebody who hasn't filed the total number of persons, you understand, it's possible to draw the attention to it if they haven't, for instance.
But my point, lawyer, is that when from the onset you make an announcement that
if you are not satisfied, go to court.
Again, per the regulations under CI 94, that not more than two persons, I mean, not more than a person. No, what am I saying? One person cannot endorse for two or more persons. And so this is in the CI. Once somebody endorses for more than one person, it becomes a crime.
Exactly.
So then the argument then is, if you have already called me a criminal because somebody endorsed for me and another person, then already you have told me it's criminal. There's no way we can have alternative dispute resolution on that. We have to go to court to settle this matter, because you realize that the posturing of the political parties and the aspirants who have decided to go to court is that this mistake can be traced to the doorstep of the EC and not them, and that they are not super gods to have known that after signing for me as a presidential aspirant, Mr. A went ahead and signed for presidential aspirant B as well.
So the point that we raise, or the point that others have then raised, is that those persons who have done those ones, the fact that they have done those ones, you have to couple it with whether they knowingly did these things, and not assume that they did it knowingly. They willingly did these things, you understand? So if these things can be established, I'm saying you can sequestrate those matters. Those things, those persons who have done can answer for it. But to throw the baby and the bathwater away, and to, how do you call it, clog the arguments of persons who say we do not know. After all, this entire electoral register has been infested with so many problems. Dead people's names, people who are, so all those kinds of problems. Easy themselves have not disqualified themselves from presiding over the election for their own problems, you understand? And I'm saying that he who comes to equity must do equity. So there are problems. But the good thing, but I do want to refer to, what Abdul said. This is a maturing democracy. And so we must actually realize that it is even a healthy thing that we are having. It's healthy. It shows the health of our country. The country can resort to rules and see how these rules play out. That is the beauty of a country that is governed by the rule of law. And so when we see these things, we must be encouraged. Look at the US elections. Those who fail most of these things tend to be lawyers. They go to them and ensure that they have proper consultations with the proper persons and ensure that these things are properly filled. It's a legal document you are filling. And for Christ's sake, it's not just any kind of thing, you understand? Because there are criminal implications out of filling it. But these things did not play out perhaps in the minds of most of our presidential aspirants.
And again, my question will be that, is there a lapse somewhere? Is it that the education on filling the form over the years, because these things haven't come up until now? Is it that the parties involved have they overlooked certain things, or the authorities involved also just overlooked it? I seem not to get. Is there an education that needs to be done for the parties from one side, which is not coming forth, or what?
In the first place, I'll disagree if you say this is the first time. In 2012, I mean, before the 2012 elections, the NDP, Nana Kunedu, was disqualified.
That's a clear example.
If you remember, Ike Donko did not qualify to go into the contest, as well as several others. At that time also, there were as many as 18 people.
Was it in
whatever it is,
with respect to filling the form?
But that's also another section of it. It's part of the whole process.
It was even that one wasn't about the forms by themselves, but the time for the submission of the forms. So they didn't even at the time get to have their forms scrutinized like the way these forms were scrutinized this year. So the point I'm just making is that this is not the first time any aspirant has been barred from contesting because of the failure on the part of those contestants, those aspirants, to do one or two things prescribed by the EC and the laws governing our elections.
Yeah.
That's the point I'm making. But then again, when you look at, and you are saying, do we have some flaws in the system? Of course, if we did not have flaws, we would not have people making the flaws to start with. But if you're asking who is to blame, everybody is to blame. Everybody is to blame, including, and I'm referring to the first point I made, including lawyers sitting here, including you and myself as reporters here, because we did not pay particular attention to the Constitution Review Commission when they were doing their work. And as we speak, where are the recommendations of the commission? Nobody knows. Probably somebody would have suggested something within those the time that this commission was working, and we would have had this issue resolved. Why are we where we are?
But
where are the recommendations? I haven't seen them.
But okay, the recommendations are one thing. I mean, the practice of them is another. But the point that I'm interested in is that, well, I do not accept that we certainly are culpable for anything, really. I reject that position. Now, my point is this, that if you are going to contest for anything, you understand, the farmers, for instance, are going to vote. They have their beef to go and think about, their eligibility and the way they cast their ballot. That is something for them to care about. Every one of us has something that we must care about, and which is our contribution to this national, exercise. Those who contest it have a more deeper obligation on them to ensure that they do the proper thing and not act in a very sloppy manner, especially where that can be avoided. Sometimes it can be. But then let me also say that I do not think that, I think the biggest room is always a room for improvement. And education can go a long way in clarifying so many things. It is high time, for instance, the National Commission on Civic Education pick some of these aspects about civic responsibility also seriously, so that they educate the political party. The political parties themselves, their political wing, political education wings, must also take this seriously. I'm sure that going forward, the filling of forms will become something taken seriously. Because if you can be disqualified just on the basis of your application form, if you can be disqualified on the basis of your application form and you do not pay serious attention to it, well, I think that you deserve what you are getting.
Look, probably you didn't allow me to. When I said we are all to blame, and I said you, I was actually referring to even the Ghana Bar Association, for instance. They're very vociferous on national issues. When it comes, and I was making reference to the Constitution Review Commission and the recommendations, the Ghana Bar Association should have keen interest in the recommendations by the Constitution Review Commission. The Ghana Bar Association should have, and I believe they did, made some suggestions for the Constitution Review Commission to work with. And I'm saying within those recommendations and suggestions, we should have had somebody seeing that, look, if we have to appoint a new electoral commission chairman, the appointment should be done by a certain period to allow her time to settle in and then start work. Maybe the time that Madame Charlotte Osei had to come in and settle was not enough to allow her space to do certain things. You remember there were recommendations for the elections to be held in November, 7th November.
Exactly.
That hasn't been able to become a reality. Why? Because there were delays in the system. Again, so when I say you are to blame, because if
but
this,
it went through Parliament and the legislature was to decide.
But the process was slow.
Okay.
If we had all thought about things earlier, including all of us here as stakeholders, we would probably have had more time. You remember that if you listen to all the parties that have been affected by the disqualifications, they will say, we didn't have time. We're just given 10 days to do this. And so you don't expect us within 10 days to go around the 275 districts, constituencies in the country, about so many other districts, and sit down and be able to scrutinize more than 500 people who had endorsed the form and so on and so forth. And I'm just saying the lack of time is what contributed to this problem. Where did we get to that we did not have enough time to do this, to the extent that we did not have time to even organize an election in November? It is because we didn't have the time, and probably we all collectively failed to
planned properly. If we had planned properly, we would not have been where we are today.
Then we all should have come
the point is
at a point.
I like your passion about the we, but I do reject the issues that are being put at our doorstep. I'm simply saying that by and large, the parties themselves have subscribed to a process. That process particularly has rules about it. They have already accepted it. This is not the time to start crying over those kinds of rules. If they hadn't, but now the rules are already in place. If you, for instance, you look at the Public Elections Regulatory LI, the CI 94, for instance, it's been there, you understand? And they have subscribed to it and are filing under it. It's not as if they have rejected anything for us to start complaining. You are not dealing with people who find CI 94 offensive. They find it acceptable. Their difficulty is interpretation. How do you interpret this? Their difficulty is the application of your discretion to disqualify me. And if you turn back to the Constitution, has the Constitution foreseen some of these things? Yes, go and look at Article 296. And it talks about the exercise of discretionary power. It should be done fairly. It should be done without caprice and things like that. So these are the things that we can never foresee all the 1,001 things that will erupt before the election, during the election, after the election, which will be of legal and social value. So whilst I do accept that generally all of us must take a keen interest, and which is what I think is one of the strengths of your argument, we should take a keen interest or a keener interest. I am also saying that the parties involved, those who have to play, if you are going to vote, you should start looking at the rules that govern voting. If you have to educate Ghanaians about voting, you should do a thorough job. If you are the electoral commissioner and you know people are submitting these things and it can clog your own timetable and clog your work, you should engage in serious education. What stops the EC from attaching people who can help people to fill forms? You understand? What is the mystique or the mischief that it will cause? I think that I'm sure going forward, if we are to learn, we on this continent of Africa are to learn better, we will do things maybe differently, because this thing is not good for the timetable. It might be good for democracy, but it is certainly not good for the timetable.
Right, it is certainly not good for the timetable. It is still the Reporters Roundtable. We will go for a quick breather, and when we come back, we'll find out whether the timing is really good for all these hula baloos and whether it will have an effect or an implication on the administration, the smooth administration of election 2016. Stay with us.
But my name is Mumin and I am a reporter. In 2012, I covered the elections extensively, but I never got an opportunity to tell you the stories behind the stories. This time around, there's a Reporters Roundtable where I, together with some of my colleagues, will be telling you the stories behind the stories.
Watch Reporters Roundtable and get in touch with some of the best brains in the field of journalism. It's a good program. All the best.
My name is Rebecca Iwa. Keep watching the Reporters Roundtable with GBC24 this and every other Thursday. Indeed, it is the Reporters Roundtable where we look at the issues from all angles and from all sides. And I know that the topic for discussion for today is very pertinent for us, and the timing is right as well. Abdul, before we went on the break, lawyer was saying something that it will be good. Looking at the suits, it is good for our democracy, but not necessarily for the time.
Of course.
Looking at the timing and all of that, how should the parties handle this whole issue? Because you know, Justice Doche, from my intro, has already said that, they should just take the whatever comes out from the courts, they should take it as it is, so that things can move on.
To that extent, I don't think that Justice Doche, and all due respect, has the right to tell parties what to do if they feel that the decision taken by the court. I believe this is going to the High Court. And once it's at the High Court level, there's another court higher than the High Court, which is the Appeal Court. And from the Appeal Court, then you can go to the Supreme Court. And
some of the lawyers for the parties have made it clear, unequivocal, that once the High Court fails to give them what they demand of, they'll go as far as the Supreme Court.
Of course.
Wouldn't this stifle the election process and all of that?
Well, you see, but the thing also is that it wasn't for nothing that those who drew up the Constitution and the judiciary itself, thought it wise to have the High Court, the Appeal Court, and then the Supreme Court, so that if anyone felt aggrieved, it's justice, for God's sake. They should, at the end of the day, regardless of the decision that is taken eventually, feel that justice has been delivered. This is the path we've chosen to go. And so we have no right. We can only appeal to them that even if it doesn't go your way, please, for the sake of Ghana, for the sake of the timetable that we have all drawn for ourselves, don't make any appeals. But if they feel aggrieved and they want to appeal, they have every right to do so. But I'm happy that as we speak, the Chief Justice says she set up about 17 courts, am I right, to deal with these issues. It's spread throughout the length and breadth of the country to deal with the issues in such a manner that 7th December will not be affected. So I also believe in the competence of the judiciary to deal with the matter even within the stipulated time. They also are aware that yes, we have these issues coming up, but these issues must be dealt with within a certain time frame, and that time frame is before December 7th. And I'm sure, and I'm very, very confident that they will be able to deliver. All
right, lawyers, so, talking about the judiciary and what the CJ had to say, is the judiciary up to the task, and can they expedite actions on all these lawsuits?
They are more than up to the tax.
Okay.
They are more than up to the tax. I mean, this isn't the first time. Look, for lawyers and for judges, this is another dispute, okay? It's simply a dispute. And it's a dispute also that festers from the interpretation of legal rules. They are competent. High Court judges, Court of Appeal judges, Supreme Court judges in this country are more than capable of dealing with this and then washing it away. Now, it's not for nothing that the framers of the Constitution created a gradation of courts for us, from Supreme Court to Court of Appeal to High Court. There can be an error at any level of them. And so you should have, and these courts have appellate powers. If you go to the Court of Appeal, it has an appellate power, which simply means that you can appeal to that court to come into a matter in which you think that you have been ill-served in terms of the justice and the equity of your case. The Supreme Court is also above the High Court. Now, there are times that the Supreme Court has disagreed vehemently with decisions even by the Court of Appeal and has overturned decisions and even gone to pick a decision even in the High Court and reinstate that decision as the more acceptable and more probable or proper, So I think that first, let all Ghanaians be calm. I think the parties are on course. The courts themselves are geared up for it. They've also set up education teams for judges and on the CIs, on the various aspects of laws that govern the election. They set up specialized courts to deal and dispense justice on these matters. I think that we must have faith in them. To the parties, and what you said about Justice Doche's advice. I think Justice Doche's advice is entitled to deep respect, but others can differ. He cannot stipulate for them exactly how they ought to conduct their business, because the Constitution stipulates that they have a right, and if the matter is justiciable, in other words, courts can deal with the matter, they should go as far as the highest court. The difficulty that I have with that process is that it's a time elongated manner of solving a problem. You will not spend less than some 20 days sitting at the Court of Appeal to do this. You might proceed to go to the Supreme Court, spend another day, another 20 days or whatever, by which time the election might probably even be over. You understand? Unless they find a way of super fast-tracking the entire process. Not fast-tracking, but super fast-tracking. In other words, moving at a jet speed. If they move at jet speed, and I don't know how, because the rules are such that the rules themselves are anti-jet speed. Some of these rules allow for flurry of motions and things like that to, and disagreements to be allowed. Motions, upon motions to be filed. It allows for them. And people will exploit it. I mean, because they think that they have to fight and they spend too much money. Look at...
But lawyer, you also agree that even, when you look at the peripheral issues that we are hearing right now, even the time frame within which the courts are supposed to sit, it's not the conventional time that we know about. It's extended time.
Yeah,
so taking all that into consideration, one would see that even the anti-jet speed attitude that you have spoken about has been taken care of already.
That's what I'm saying. I mean, and that is what you are hitting on. That is the jet speed kind of thing I'm talking about.
That you're proposing.
I'm proposing. And the point is that even with that one, the nature of justice is that it grinds slowly.
It's very slow.
Because why do I say so? You could be filing motions, and you could be fault finding the process. You understand? And so some of those ones, you can never always predict what happens in a courtroom.
And whatever happens also sets a precedent.
It sets a precedent.
Yes. So
and beyond that one too, don't forget that a court of first instance is not the final destination. The high court that we are seeing is not the final destination. And nobody can stipulate any of those ones until the Supreme Court has pronounced on a matter as being final in Ghana. You understand? And so it puts a cloud over the election. We should not forget that. It puts a cloud over the election. That cloud is not only a legal one. It's a security one. That cloud is also not a security one. It's an economic one. Because when the parties are going through an elongated process, such as I have described, they are spending money. They are spending a lot of money doing research and money doing... Supporters have to be energized. And they are energizing supporters.
I'll come to the supporters bit. I'll start with you, Abdul. But talking about the judiciary, is it... During the week, there was the CJ's Forum. When I talk about the CJ's Forum, the Chief Justice's Forum, and the Chief Justice herself made a comment that the judiciary is more than capable. I would want us to watch that video for a short while, then I'll come back to Abdul for his submission on aggrieved supporters who even besiege court premises because their party storeholders have spent a lot of money. So we'll come back shortly after the video.
The Chief Justice's Forum is a yearly colloquium which brings together the bench, the bar and other stakeholders to evaluate the performance of the judiciary. It also offers the judiciary the opportunity to open up to the public. With the 2016 general elections just a few weeks away, this year's version of the program focused on the judiciary's preparedness to deal with electoral disputes promptly and fairly. The Chief Justice, Justice Mrs. Georgina Theodora Wood, said public confidence in the judiciary is essential for national peace and development since it prevents people from taking the law into their own hands.
At a time the High Court rules have been amended to provide for witness statements, I am confident that the maximum professional diligence would be deployed by all judges in adjudicating the multiple suits being filed ahead of December 7th, 2016.
Presenting a paper on the judiciary's preparedness towards the 2016 elections, a Supreme Court judge, Justice Jones Doche, said the court system is undergoing reforms to ensure that electoral integrity is protected.
As we go to the elections, we wish to assure the good people of Ghana that we shall deal with cases which are filed before the courts expeditiously, bearing in mind the fact that issues turning on elections need to be quickly resolved. But in order to achieve this, we count on the cooperation of the parties and their lawyers who must appreciate and understand that cases relating to elections must be given priority over other cases.
The Chief Executive for the Institute for Democratic Governance, IDEG, Dr. Emmanuel Akwete, said there is the need to put measures in place to forestall conflicts.
Hoping that my advocacy for a stronger social role for the judiciary would go beyond the petitions and the cases, but also engage in the wider processes by which you probably could insist that the parties do more dialogue, because they are running away from dialogue and compromises, and the choice between the Supreme Court and violent options are truly not choices we should entertain.
The forum was attended by the judges and magistrates, members of parliament, members of the Ghana Bar Association, and security agencies.
So there you have it, the comments of people in the learned profession. They have told us that they are more than capable to tackle these issues head on, moving forward to election 2016. Abdul, but we know that there are supporters who are very angry. And a hungry man, they say, is an angry man. And they besiege court premises, supporting their, presidential candidates and all of that. How do you measure the tensions in the system moving forward to our elections?
You know, again, around this time of the year, I mean, every 4 years when we get to this time, I hear the word tension so often that I tend to think, what's the definition for tension? How do we contextualize tension? In my own estimation, I don't feel any tension in the country. I've never felt tension in the country ahead of any of the elections that I have monitored. Even the day that the Supreme Court was about to announce the results, I mean, the decision they had arrived at after the election petition hearing, people were talking about tension. I didn't feel any tension. What I am feeling right now is a certain fever, a certain political fever, which is a very natural thing. You go to the US today, where they're also preparing for an election, a major election at that. The same fever is there. They don't talk about tension.
But there are no lawsuits. And all of that.
But I'm coming to. I mean, the point I'm making is, when there is a football match between Asante Kotoko and Hearts, you go to the stadium. Let me take you back to 2008 when Ghana hosted the Africa Cup of Nations. Everywhere you went around the country, and it's not tense at all, and we should stop describing it as a tense situation.
Okay, but for the supporters of these parties, how would you describe what is happening now?
Okay, but before I do that, I mean, let me make just a brief comment about what
Abdul said.
In part, I agree with him, but in a large measure, I disagree. I do not think that the word tension itself is a problem. Even at home, you have tension. In the studio, there can be tension, you understand. It depends on the gravity of it. What he has been talking about, if I understand him correctly, has rather to do with the gravity of it, because it's like a spectrum, standing from one point where there's a mild tension to a point where there is indeed anarchy or extreme tension. You can actually use adjectives to qualify it to make it. But tension largely, if you look for instance at and I'll just check in to find out what is the meaning of it, and if it's etymology. Look, the word tension is simply defined by the Merriam-Webster dictionaries is a feeling of nervousness. And so let us have there's no fetish about the word tension. It's just a feeling of nervousness. You are not sure whether after all this, whether you will even become a candidate. You are not sure whether the rules will be applied fairly. You are not sure whether this is a deliberate orchestration. You cannot tell me people like Nana Kunedu, for instance, who were disqualified first time and felt very aggrieved and thought that this year they had done everything, think that this is the type of... So they will be sitting on tenterhooks because anything can happen. If the electoral commissioner can erupt with one statement and say that, hey, fellow Ghanaians, 12 of the beauty contestants can go home. They have been disqualified. I mean, I can't, and the courts can also do same or do otherwise or whatever. Tension doesn't erupt in a day. It starts building up. And so for those who are security watchers, a discontented group is a group you must watch. Because in a night, they are capable of doing anything to push up the stakes. Maybe the stakes are not too high to them. They feel that the others are not feeling what they feel. So they have to paint the right picture. Painting the right picture will be interpreted differently. Let us go and do this. Let us do this. Let's do this. That is where this kinds of tension, the nervous situations erupt. So I want us to actually look at the word itself and apply maybe the right adjectives in. I mean, to say maybe there's extreme tension in Ghana, for instance, might be an overshot. But there is some mild tension going on. Because I passed around and saw people carrying red flags all over, and you could see a whole street of people. And these are people who have members around the entire country. They only need to be told that do so and so. Don't sit down. We've been told in this country many times, don't sit down, make them cheat you every day and all those things. You only need somebody to just inspire people that do this, and then they will do it, because the supporters are waiting for signals. They are like foot soldiers. They are just sitting waiting for a signal. There's a section who go and sit at home and say, okay, fine. There are those who want to be on the street because picketing gets action. So I do not want us to actually paint a wrong picture for ourselves, because I'm sure that if what we are seeing goes on, probably the good messages that journalists, the clergy are pouring and all those ones, and you heard what what's his name, Doctor? One moment, please. Yeah. Doctor, what's his name? I just would end. What's his name, Doctor?
The man from IDEG.
Yes.
Dr. Kwete.
Dr. Kwete was saying they are running away from talking to each other. They are running away, which is what, for instance, one of the, how do you call it, has been my message. You are running, yes, you are running away from dialogue. You are going to court. You are ready to dialogue rather in court. You should find a way. Next time you have a problem like this, find a way to create buffer periods where you can actually meet the beauty contestants who are, and tell them that shape up this way or shape up that way, blah, blah. You see, there must be room. That's why somebody or our parliament thought it necessary to think about alternative dispute resolution. Don't clog everything into one whole called litigation.
All right.
Talk. So
that is let me just really like litigation. They will want you to resort to ADR before you.
Just a quick one on to react to lawyer and the use of the word tension. And you refer to the dictionary definition of tension, and I do respect that. But I also know that you know that words really do not have any meanings, even if the dictionary tells us so, until we contextualize those words. And I work in an industry that the word tension has been contextualized and used consistently in a certain way, that any time that word is used in that industry, the media industry, it comes up with some connotations. And these are the connotations that I'm looking at. Tension in Nigeria, and that's a headline, and then you're looking at the pictures and you're seeing Boko Haram and the bomb blast. Tension in Kenya, and we're seeing 2007, and then tension in South Africa, and we're talking about xenophobic attacks on non-South Africans and so on and so forth. And so consistently, the word tension is followed by violence. And I'm saying that we are not preparing the grounds for violence. I don't see that.
But I agree. That's why I said, in part, I agree with you. The only difficulty I have is that what we still have still qualifies as a tense situation. It's a situation of nervousness.
We are not able to manage it.
And for conflict analysts, for conflict or security analysts,
the definition of tension.
No, I'm not talking about the definition. I'm saying that for conflict analysts or those who are concerned about security, it is a trajectory. It starts with discontent, which itself creates a form of dissonance we call tension.
But luckily, we have the legal process, which
it's also a tense area.
All the parties
even when you go to court,
anyway,
even courts are tense.
Right. Enough with the tension. But Abdul, looking at all that is happening, would you say that we are heading towards a more secure future or instability?
Again, maybe I'm being too optimistic. but I really.
But where there's a plan A, there should be a plan B.
Anyway,
yeah. When you talk about, are we headed towards a more secure future, or what was the other instability? I don't see instability ahead of us. We've come too far away from instability to go back into it. We have become too mature, and if again, on forgive me for always going back, in 2013, because I was deeply involved in that coverage, on the day that the Supreme Court was about to announce, whatever decision they had come to, reporters were on the streets of Accra. The streets of Accra were virtually empty, if you recall. Everybody thought something was going to come up, and so everybody ran inside their homes. So the question that I asked myself, so who is it that was going to create or cause the problems if all of them had run indoors? Naturally, I may be too optimistic, but the Ghanaians are peaceful inward. Nobody, even though we are so much into politics and we have so much divided ourselves along political lines, when it comes to the issue of violence, forgive me, I trace it to other institutions other than politics. Other institutions, I don't want to mention them here, but they use politics as a cover-up to do those things. But you go within, and it's got to do with either chieftaincy, it's got to do with land disputes, and so many other things. But the basic root cause is never politics. And I have done some conflict studies as well. I've written a whole thesis on conflict studies, and these are empirical evidence that I have found that usually it's not got anything to do with direct politics, but the peripheral other issues that people use to front for themselves. I mean, to cover up. They use politics as a cover-up in order to achieve some other ends. Yeah. So security. I don't think we're at risk at all. We've come too far away from instability. We will not go back to it.
Sure. Lawyer, yes. You gave me this beautiful book, Dixon's Principles of Security. Dixon on Principles of Security Law, Test Cases and Materials, Law for Security and Intelligence Professionals. This tells me that you've written this beautiful book on security. What exactly did you find with the question I posed to Abdul pertaining to what is happening now in our country? Researching forth and going forward, do you see us moving into an area of instability, or we are just doing fine? The way we are going, it will rather strengthen our democracy and help us move forward.
Okay, there are various ways of looking at it. I mean, as somebody who has done a very extensive study on security, there's one consistent thing that I find. There are various actors in that field. There are those who have to look at what others do and also see whether they are acting in line or out of line. There are those who have to forecast and look into the future to see whether or not we are staring at problems. We call those people intelligence people. The intelligence profession, the DNI and the research departments and all those things. They are deeply concerned with not specific police security, military security. They're interested in national security. So they need to be able to foretell, look at the early warning signals that are coming and interpret them appropriately. You understand? And the period of election, like what Abdul has said, is a period fested with a lot of concern. Sometimes you have issues to do with discontent. I say you have tensions and tensions and tensions of them within that type of period. Now, in the period to that election, the other actors, some of the other actors that you would expect would be the police, for instance, will be the National Election Security Task Force and all those. They have to act in an even manner. If they act in a biased manner, which is very clear to people and who feel very dissatisfied, you would move from discontent to some active tension in the country. If they feel that the process has been rigged or inherently is unfair, you would have organized groups organize themselves to be able to stem or to stop that kind of thing, which is therefore something that intelligence people would watch. They would watch for groups, for instance, some will call them troublemakers, others will call them people fighting for their rights and all those kinds of things. All these groups exist in this country. And so there must be a balance in terms of the application of the rules. The rules that are applied must be fair. So I call on anybody from the EC, political parties, to open their eyes wide and be concerned with Ghana, not with parochial interest, parochial interest of the EC, parochial interest of their political party. Because if you do concern yourself with only that small quartet, you understand, then probably you'll be promoting that type of interest. And that would lead to a very skewed application of rules that will engender problems. The political parties are spread across the country, the major ones, and therefore they have supporters around the country, you know. And this kind of election that we are going into is a crossroad election. It's a watershed election, both for the MPP, for obvious reasons. A 3-time presidential aspirant who hasn't succeeded the first time, succeeded the second time, and who is attempting a 3rd time. There is on one hand the possibility that 3rd terms in Ghana tend to be successful, and so it's a watch for those who are incumbents. There's also an incumbent government that believes that they're doing the right thing, you understand, and who can see visible signs of what they have done around and why they deserve another term. And so it poses a kind of make or break kind of thing. And because of one particular problem in our politics, tension will never run away when we come to elections or selection, which is winner takes all. If you run a system where you have a winner takes all, and which is what happens in this country, then sometimes, and not sometimes, you do have a festering problem for your country itself. One, let me describe exactly what I'm talking about. Ghana, to me, is like a country, or like it's like a bird that flies with only one wing after election. The political party that wins is the only one that seems to fly, because of obvious reasons here. Or you can liken it to not a bird, but a goat. Ghana is like a goat that has 4 legs, but after election, it walks with only 1 leg. The political party that wins. There is no space for party, mutuality, bipartisanship, and all those sharing of positions across. So it's like you win, you appoint all the ambassadors, you win, you appoint everybody to all the boards, you win, all the everything is yours. And so it makes the capture of political power a very important issue for why people get into the politics of their own matter. Because if they lose, they spend the next 4 years actually in Siberia. Contractors, for instance, from certain, have to show that, okay, I'm a card-bearing member. You understand? So we have that type of problem. It is something we must transcend. And I hope that in the fullness of time, the advisor we have received, for instance, from Kofi Annan, the advisor we have received from some of our luminaries, people like Ibn Chambers, people like Pamabaka, yes, people, the IEAs, you understand, who point to us that the former American ambassador who left Ghana, he said that, look, there's a problem with this problem, a practical problem with this winner takes all thing. It is at the root of so many of the deep agitation for power, the hunger for power. It's because you will spend the next 4 or so years or more deeply hungry and even thirsty. You'll be thirsty. So that's my problem.
Before I come in, I want to come in from an informed position. So right. I would appreciate if lawyer could maybe, and I've heard this term used over and over and over again, winner takes all.
Okay.
As against what?
Okay. Now, most political systems that advocate for a situation where you don't have a winner takes all. It's like let me use winner takes all versus winner works with all. Winner takes all versus winner takes with all. Now, yes, we've inherited a system which is alien to us. It's from the white people. Our constitution has deep segments that are being borrowed from the American system without the cultural underpinnings of the US system. We have borrowed also from the, the Westminster model, and without the underpinnings of their culture, you understand? And so, whilst in those systems, it is, for instance, possible for Obama's, his defense minister, to be from his opposition. He was going to war. And you would expect naturally that he would pick able people within the Republican Party. He picks Robert Gates. I mean, could you imagine that maybe the foreign minister of Ghana will be a stalwart within, maybe, for instance, if it's an MPP, it's an NDC. Or if it's NDC, I'm just answering your point. So what happens largely is that there's a certain culture of working across board or appealing to other political parties within a particular state. And sometimes others have thought about even proportional representation, which, well, it's a constitutional matter to be dealt with. But what I'm talking about is, at least at the barest minimum, that culture of overlooking partisanship, extreme partisanship. Because if you appoint somebody from the opposition, you get a huge flag. We've seen this in this country where they've tried to appoint people from across.
People have worked for the party to come to power. And why would you want
but
to
it hasn't been accepted as a norm, you understand? To stem sometimes that extremity where it's only us. If it's MPP that wins power today, everybody who is appointed to any significant or position of significance must be for. It's an unwritten rule, and occasionally some must be done for. They must begin to reconsider what those of us who are kick against those systems are. Forget about the party, because you might have good people from the other side who can help to build this country. If you are in Party B, you might not have all the talents. So that's our issue. When we talk about
because when this issue comes up, it always leaves me more confused than before, because for instance, in 2009, between January and March, DCs who belonged to the previous administration, the Kufuor administration, were left to work. They were not asked to leave their positions by the then president, late Professor Tamils. His own party people descended on him, criticized him for leaving opposition elements at that level. Recently, and you are talking about all inclusive. Is that work with all kind of government as against the winner takes all kind of government? Yes. Mr. Emmanuel Bombandi has been appointed as Deputy Minister in charge of Foreign Affairs. I don't know him to belong to the NDC. I don't know him to belong to any political party. I just know him to be an astute security expert, somebody who has deep knowledge in international affairs, and somebody who qualifies to be even the substantive Minister of Foreign Affairs of any country in Africa.
But Abdullah, I think what these people are advocating for is, Mr. Emmanuel Bombandi's case is 1 in a million. I think they are advocating for more inclusiveness.
I'm coming to a point. He's appointed, and instead of those calling for winner takes all to be put aside, I hear people once again saying, we didn't know he was NDC. We are surprised. Why did he accept the appointment? We didn't know he was NDC. All of a sudden, he has become NDC just because he's been appointed by the NDC government.
No, then we should be doing some more education, because if the person is an expert in that area, irrespective of your party inclination or your party affiliation, once you can do the job,
the point I'm making is that the blame should not always be put at the doorstep of the appointing authority. Whatever you do, society will reflect some of the decisions that are made at the very top. And society says, once you appoint this person, then it means he's a member of your party. And so you find out that there are so many people, lawyer, and I know you know them, who are the intellectuals. They know, as we say, what's up. But because of the kind of attitude we have towards our politics, once we approach these people, the people who can govern us in a winner takes all, work with all,
winner works
with all kind of situation, they will refuse any appointment from any government whatsoever, because they'll be painted with political party colors.
Anyway,
Rebecca, if you allow me just 30 seconds, please, just 30 seconds. But even when we talk about winner takes all, hasn't the Constitution already puts in place the checks and balances? We have Parliament. Parliament, for God's sake, is not made up of one party. For all I know now, Parliament is made up of at least 3 parties as we speak, and some independent members as well. Do they not form part of government? Government cannot take any major decision without the involvement of Parliament.
But we know in Ghana, because of the majority Exactly, it influences the kind of decisions and laws we make in our parliament. But not to go there that much. Let's focus on what we are talking. We are discussing. Abdul, let me find out from you. How do you see the security architecture of our country?
You know, again, let me come from a reporter's point of view. 2 months ago, I went to some of the, you know, the areas that have been described as flashpoints. I understand there are 81 of them which have been identified by the security experts. I just decided to, as a reporter, go around. I haven't finished my rounds yet. I've been to Bimbila, been to Yendi, Gushegu. You know, soon I'll be going to Bunkurugu. You know, but I'm just saying.
Why are you focusing on in the north?
If I have access, if I have access to any other parts, I will go. Okay. These are places that I can have easy access to, and so accessibility is very important in this process. But the point I'm making is, armed robbers attacked the vehicle that I was traveling in the dark of night, and they shot at the car, injured the driver. The report was shown on GBC24 and on GTV as well. They injured the driver, and they were waiting to see if there will be any response from the vehicle before the attack. We quickly put in a call to the police, and within a matter of 10 minutes, and I wasn't expecting any response, to be honest, but within a matter of 10 minutes, the police arrived on the scene before the people could come to the vehicle themselves to steal. They attacked, they shot at the vehicle and stopped it, but they didn't have the confidence, because usually they also want to strategize. Maybe somebody else would be there who might have a gun to shoot or something, but within 10 minutes the police came and the people escaped. Even though they escaped, for me the good news was that apart from the driver, nobody else got injured and nobody lost any property of theirs. And so I'm saying, and the story I was doing at the time was, okay, people are traveling along these routes. How safe are they? The police proved to me without an interview that they are ready, especially on that stretch of the road, to defend and protect people during these times.
Would you say that cuts across?
I'm just speaking from what I know. I cannot speak about Elubo. I haven't been to Elubo. So that's why I mentioned specific areas that I've been to and the experience that I have had. And then you speak to the police commanders in the various regions that I've been to, as well as listening to the IGP himself. He tells you that we are ready. And I want to believe that they are ready. Otherwise, and the good thing is that there are some parts of this country during the elections, you won't even know there's anything going on there, because people go, vote, and they leave. There are other places people go, vote, and stay. And these are the flashpoints. And the good news for me is that the security forces have been able to identify these flashpoints. They've given us the assurances that they will be able to ensure security at these places. I don't want to take anything else but believe in the message that they have given us so far.
Yeah, Dixon.
Yeah, I mean, flashpoints are generally areas.
What exactly do you have in your book? Has the book been launched?
No, it's going to be launched. It's going to be launched, and it's good you're mentioning it. It's going to be launched on the 1st, Tuesday, the 1st of November.
Okay, then you're lucky to have one.
You are, yes, you are. And in fact, I urge everybody to be there at the British Council at 5 o'clock.
This one is free adverts.
Well, that's why we engage in a bit of the public advocacy for your program, Becky. Okay,
right.
And so we want everybody to come. But that's a copy of the book. Now, you've asked a question about what I make out of. Yes, we have flashpoints in this country, and the Electoral Commissioner itself, I think they brought some 81 flashpoints.
81, yes.
But the National Election Security Task Force nationally has identified about 5,000 flashpoints. 5,000 flashpoints. That's quite a number.
That's a huge number.
That's a huge number, yes.
Considering the number of security personnel
that you
have. Yeah.
If you identify 5,000, do you have correspondingly 5,000 well-prepared, how do you call it, contingents with...
And just to buttress your point, the Small Arms Commission says there are 2 million unregistered weapons out there. And if you look at the statistics, the security personnel who are permitted to handle arms are just about 150,000.
Wow.
So if we would have, and God forbid, a situation where we have 2 million illegal weapons out there to face 150,000 legal weapons, then you can easily tell who can win.
Not to catch you, but we have this story in, and I want to read it out for the benefits of the program, that the Accra High Court has struck out the suit filed by the flag bearer of the National Democratic Party, NDP, Nana Kunedu Ajiman Rollins, challenging her disqualification by the Electoral Commission. The court also awarded a 10,000 cedis cost against the disqualified flag bearer. The presiding judge, Justice George Kumsing, in his ruling said the court took the decision because Nana Kunedu adopted the wrong procedure in coming before the court, which renders the suit incompetent. Justice Kumsing indicated that the applicant was wrong in applying for both judicial review and an enforcement of fundamental human rights in the same writ. Meanwhile, counsel for Nana Kunedu, Ace Ankoma, said he will file a fresh suit on behalf of his clients. I think this is a determined lawyer who wants to go all lengths. Yes. But Abdul, I'll bring you in shortly. But let me find out from lawyer. How relevant or how important is the procedure that you ought to follow? Be seeking an injunction, be seeking whatever redress you want to seek. How important is it for these filing of suits?
Wow. In fact, this is really surprising for all of us sitting here. I mean, I think at this time. But the very first comment that I want to maybe say in reaction to your question is this: that procedure is part of law. So you have the substantive law, which is the actual law, which says X or Y or Z, and you have the procedure for getting that law enforced. And if you have to pass through the door and you pass through a window, then you can be booted out. I'm not too sure, because of the paucity of information that has just gotten to you, that whether we are able to actually determine or evaluate what kind of procedures or mechanisms they put in place to harness the results that they wanted. I'm not too sure about that one yet. In the fullness of time, I'm sure we would.
If you were to be a lawyer for any of them,
which
way would you have gone?
No, the first thing that you will do. Well, no, they asked for judicial review. Yeah. And what again did they ask for?
Applicant was wrong in applying for both judicial review and an enforcement of fundamental human rights in the same writ.
And so that they needed to have actually separated or have chosen one kind of remedy. You understand? I'm saying that, I mean, if you look at the application that they have, the affidavits and all those ones will avert as clearly as to why they chose both. If you look, for instance, under Article 33 of the 1992 Constitution, it addresses the High Court and its rights to give remedies such as they are asking for. You understand? So that is one. And I do not think that it would occur to them that should be wrong in asking for maybe the enforcement of those rights, and also in asking for a judicial review of a decision taken by an administrative body. The EC is an administrative body. Its decisions are not judgments. And so you can ask for the prerogative rights that the court has to strike those decisions down, or to even annul them, or to vary them, and so on and so forth. You understand? But possibly, I could say this, that a lot of lawyers actually adapt those procedures, because sometimes you read the Constitution itself, under Article 33, it doesn't sometimes give you a very clear idea that you have to choose only one kind of method at the expense of another type of method. And that is why I think that Ace Ankoma might have coupled his application with those two remedies before the court. This is a pronouncement of a court. Two things can happen. The judge himself, whilst he's entitled to our deepest respect for the decision that he has come to, it does not actually end the right of the applicants to go to a higher court, to an appellate court like the Court of Appeal, to seek, how do you call it, a different decision from that court, because I'm sure they would disagree with this judge. And
Sankuma is saying that he will file a fresh suit altogether on behalf of his client.
Oh, then possibly that's a new application.
A new application. So that is what I was talking about. Time is of essence, and this is a man going to file a new suit altogether, and this will drag on for another day. I'll come back to you, Abdul, quickly for your comments on this particular development. Then we'll see how it pans out. It is still the Reporters Roundtable. This program is highly supported by Health West Ghana and Atrifiawe. Stay with us and send in your comments.
Journalism is dynamic, and as part of our responsibility, we are supposed to go out there, fish for information for the public. Today in Ghana, it is our duty to ensure that the masses know what is going on in society. Reporters Roundtable is a program that you can get all these things. Watch Reporters Roundtable with Rebecca Iwa this and every Thursday.
Reporters Roundtable is a platform for journalists to express their views on topical issues objectively. This and every Thursday, you don't want to miss it.
Okay, welcome back to the show, the Reporters Roundtable, all angles, all sides. Abdul, before we went on a break, we had this new development that the case of the NDP has been thrown out. A quick comment.
Very quick, and again, I won't pretend to know any of the legal processes except to look at it from a reporter's point of view. And I was listening to you said wrong procedure, these were the key phrases, and fresh suits. These were the things that I heard. So the judge simply said, we are throwing out the case because you used the wrong procedure, and the lawyer for the NDP says we'll come back with a fresh suit. And for me, listening to the CJ, the Chief Justice, and then Justice Doche at that the CJ's forum speaking, and the fact that they have assured us that they will work expeditiously within stipulated time, I was hoping that the judge would be specific enough to say that yes, you use the wrong procedure, but should you wish to come back with a fresh suit, you have to do that within 2 days or 3 days or 1 week, so we know. But that for me is absent. Either it's absent from the story, or that if it wasn't stated at all, then for me that is very problematic. These are the little details that can get all of us to begin to worry. But if we were specific in telling the NDP and their lawyer that if you wish to come back, you have to do so within 24 hours, within 48 hours. Failure to do so, we will not listen to you again. That for me would have been better news than what I'm hearing right now.
Yeah, but would that save the cause of justice?
Yeah, but the point is that we must concede that the information that we have available right now is scanty. Yeah. The paucity of that information doesn't allow us, the Lazarus, to make too many pronouncements. But at least you can glean from what lawyers for NDP are saying, that they will revisit the court with a fresh application. If you look, for instance, at Article 33(3) of the 1992 Constitution, it permits persons who are aggrieved by a decision of the High Court to actually proceed to Court of Appeal and proceed further to the Supreme Court. So I'm sure the lawyers know exactly what to do. By the decision of the court, they now know exactly what to do. They will not be left in any doubt as to the right procedure now that the judge will entertain.
But how quickly do you foresee the courts adjudicating these cases?
You are asking $1 million question.
I'm just confident that they will be able to see through all these cases before 7th December. That I'm confident. But I'll begin to lose confidence if judgments like this are delivered, and I hope what I'm hearing is not the exact case, without a specific time frame given.
Okay. Yeah, but the point is that, you see, when it comes to a court fact-based matter, which is litigious, regardless of wishes, I wish it to be fast, I wish it to be slow, it has simply no place with, because at the end of the day, you file and you are being told that, look, you are booted out. You coupled your application with another remedy. You're asking for 2 remedies. You should ask for only 1 remedy. The person says, okay, I'll go back and return to you back with 1 remedy. He brings his 1 remedy. It takes you, for instance, about like a week or 2, or even 3 days to not 3 days, because there's 3 days.
Is that to suggest that if the person comes seeking for 1 remedy, then it's justiciable?
Yeah, well, from what you're saying, I mean, we are yet to find out. That's why I'm cautious about those ones. But what I'm simply saying is that if you decide to elect even to come for one particular remedy, don't forget that you need to go and file and give a certain number of days to the other side to respond. Yeah. It's a motion that you are, it's an application that you are making. They might file an application in opposition to your own application, you understand? And so they need to also have time to study it and refer the court to proper procedures, proper laws, all those kinds of things. The judge also needs time. He's a human being, he's not a machine. He needs time to go and sit down there, not like a robot, but like a human being who understands the nuances of his environment and also the legal issues that are called into question, and then make a pronouncement. It takes time. Now, after he has done that one, the judges are, all the lawyers on both sides are entitled to either agree or disagree. Both can even agree that that's the right judgment. There will be no problem. Or they can say that they accept the results, but they reject the reasoning, for instance. Or they fault it for it, or the judge failed to consider this or failed to do this. And then they'll go to the Court of Appeal. The Court of Appeal also has judges waiting for these applications. When they also go there, they can also fault find the same application for various things. Then they go to Supreme Court. The Supreme Court judges are even more rigorous in all these kinds of things. And even though they want to do things expeditiously, I caution that don't be too expectant of them. They need to actually make pronouncement that becomes the final law in the land. Theirs is the final one. All these ones are not the final law in the land. The final one only comes from a Supreme Court. So they take time to make decisions that will stand the test of time.
And we have less than 40 days to elections. And I read on the net that the EC is also complaining that it is delaying the printing of the ballot sheets. You understand? Because
how do you go ahead?
How do you go ahead when
it's not just the printing. Yeah, the EC even hasn't gone ahead to ballot for presidential positions on the ballot paper. So once you haven't even done the balloting, how do you print the sheet? So the balloting comes before the printing. That even hasn't been done. You remember that last week, that for the parliamentary candidates was done, and even that, those who will be contesting as independent candidates still do not know their positions on the ballot, because that hasn't been done at the constituency level. So there's still a certain gap, a huge one, that needs to be filled. So
Abdul is right. You see, he's absolutely right. Now, there are fallouts of all these ones. The biggest damage, or the biggest, how do you call it, inheritor of the damage, is the people of this country.
Yeah.
We are sitting on attention. We don't know what will happen. We never can tell what will result even in court. And the EC is sitting on a bigger tension because the manager of the process. Now, you don't know who are you going to call to come and ballot, when others are claiming that the court is going to actually put them back on the ballot box. You understand? And then also, what about the parliamentary ones? All those are going to... So what is going to happen? And I wish they would talk. I wish, or part of the things that are being asked for, you understand, they will find a way of dialoguing. In fact, in future, I will regret being a Ghanaian if our EC and the political parties cannot talk. Because from all that I have seen, no talking goes on. All that goes on is that we disagree with you, go to court to do this. And I'm saying that approach, even though you have the right to go to court, you are going to put not only yourself fighting for your right, but the people of Ghana actually, because this election actually can be postponed. From what is going on, it can be postponed.
When did they start talking? The EC and the parties, right? Because I know there's IPAC and they have IPAC meetings.
Yeah, they have IPAC
regularly.
They have IPAC. When you tell me to file within from 23rd September, and I should file my thing by 30th, and I actually do so, and you say, I did it in I didn't do so expeditiously. then you go ahead after a very short time to come and announce that you have identified so and so forth, and that is the end of the matter, and you can go to court. I'm simply saying that you have the right to tell me that. But if you look at the public interest, you could find a way of sitting at it, because nothing stops you. If there is a law that stops you from doing that, in fact, Justice Broby, in a discussion with, in a paper that he presented to a group, an arbitration kind of group, actually postulated that there is nothing in our law that prevents, for instance, electoral issues from becoming a major issue for alternative dispute resolution, which is faster. Sitting at this table to agree on that, okay, fine, you haven't done this, so do this, do this, do this, do this. It is far better than allowing lawyers to file things which have time periods and there are so many nuances about a law. And the fact that the judge pronounces doesn't mean it's the end, until we have gotten to Supreme Court. So I don't really want us to focus our elections largely without that kind of rapprochement, that kind of dealings. It's important.
From your journalistic perspective, would you say that the EC applied the law so strictly?
If you speak to the affected presidential aspirants, and I've spoken to a few of them on the same channel, you get an indication. They point to certain flaws even on the part of the EC itself, and they refer you to some of the recommendations made by the Supreme Court for future elections, recommendations which the EC itself has not been able to meet, and yet is going ahead to organize another elections. And then they refer to the political parties law, which basically also recommends that political parties must have offices in at least 2/3 of the 275 constituencies. Not all political parties have met that, and yet the EC was relaxed, in applying that law, and so it allowed political parties to proceed, even though they didn't have representation in all the 2/3 of the 275 constituencies. And so, to that extent, they thought that, well, you cannot approbate and reprobate at the same time. At one point, you decide to relax the rules. At another point, you decide to tighten the rules. And there's a certain conspiracy theory raised by some of those same affected, disqualified aspirants that had it been the two major parties, would the EC have had the courage to take the same decision? I don't have the answer. But it's a very interesting question for me, and I wish one day somebody will come up with the answer.
And lawyer, to the extent that we're encouraging multi-party democracy. Is this good for us?
Oh, I think that it's healthy. I mean, I have made that point earlier, but
because obviously the turnout of events seem to suggest that it is. We are just it's a two-horse race. There's nothing
but you know what should happen? I mean, and I think maybe probably Abdul alluded to it. Look, you have an IPAC, okay? I think that we are trying to find ways of institutionalizing IPAC. Why? Because we are thinking of dialogue, and I keep on emphasizing that point that we Ghanaians should be able to talk to each other when we have formed institutions that should govern our affairs. We shouldn't lead everything to, litigation to solve our problem, a third-party judge having to pronounce on it. I'm simply saying that we should institutionalize dialogue for a very tenuous process like an election, education, helping people to fill their forms and communicating that information clearly to them, letting them, they are part of the process. They will create tension in our system if you don't do that. The process can become elongated. Injunctions and other, even frivolous applications can be filed, you understand, by these enchanted persons. So I think that, in a way, it is good it's gone to court so that the rules that govern election, for instance, can be clearly elucidated. That one is good. But we should actually look at situations where dialogue is important.
Okay, Abdul, there's this school of thought that says that, moving forward, then political parties or pronouncing them as candidates or otherwise should precede they going around the country spending more money, pushing more money into their campaign, and later they find out that after all we are not even on the ballot box.
Especially now that we've heard from some of them who say they have spent as much as $4.6 million already campaigning.
It's a slip of tongue, actually.
But we are also aware that Dr. Parkus Indun, for instance, is having some issues with the IOCO over monies that were paid and all that. So yes, I think that's a good suggestion. But again, looking at our timetable and looking at so let's use the NDC, the MPP, and the CPP, for example. They have gone through, and the independent candidate Jacob Asaya-Boa. So if they had waited so when the EC made the announcement, what kind of impact would they have made in their campaign so far? When would they have come up with their manifestos and so on and so forth? I don't think, yes, it's a good idea, but when you bring the time factor in and the fact that we have a huge country that has to be covered by all these aspirants, for me, it doesn't make too much sense.
Wouldn't it be like readjusting the timetable of the EC so that we wouldn't end up being in court?
Some political parties say, I mean, per their own constitutions, internal constitutions will tell you that, look, we will elect our presidential candidate 2 years ahead of the election. If the EC's plan is that let's have these confirmations done 6 months to the elections, how does it pan out? I mean, it's
still a very open kind of thing, very fluid for discussions. I mean, my view is that, I mean, after maybe all this hula baloo actually dies down, perhaps we have some learning to do. And like you rightly mentioned at the beginning, I mean, there are a lot of recommendations that were made. I mean, the EC, for instance, perhaps might want to take a second look. I mean, so I think Madam Charlotte Osei has a lot of, I mean, she's new in her job still, okay, but she has clearly certain things to learn. I mean, and I hope that those learnings will be done.
Okay, all right. This one says, my name is Maski. The December 7 lawsuit, the December 7 election cannot be changed. The lawyer, hey, Maski, this is your message. I can't see the head and tail of it. I'm sorry, but thank you for the message. I think you're making reference to something the lawyer said, and it's a constitutional amendment, so it cannot be changed and all of that, right? Okay, so lawyer, finally, what can you say? You said you're launching your book and all of that, and what advice would you give to Madame Charlotte Osei, the body, the EC itself, regarding the fact that the NCC have not been resourced well to do all these educations, and we've ended up in court, and also the political parties that have been affected? Okay,
I mean, I think that the first important thing, I mean, in my book, for instance, I talk about, how do you call it, the issues to do with rule of law. You understand? It is a main premise on which I realized that there was a need for something to remind our security agencies and our security forces, particularly also Ghanaians, for Ghanaians to know their rights. The Electoral Commission that uses security apparatus around the entire country to use people who are deeply engrafted in law. They have to understand the nuances of the elections and then the rights of the people who they go after, especially where there are problems. We have public order laws and things like this, and these are things which comes into issue when you are dealing with elections because of affected people here and there. So it's a simple thing to the EC that be guided by rule of law and be guided by an exercise of discretion that is tempered with law. Constitutional law, for example, and Article 296, talking about how fairness, candor, not the absence of capriciousness, making declarations that are capricious, you understand? These are to be avoided. To the political parties, I would urge them to also consider the issues of law, even when you are even when you are disaffected. Even in war, there are the laws of war, you understand? And in peace, there are the laws of peace. So there are civil laws that still govern us. And the fact that you are disgruntled or you are not happy with something should not become, an excuse for the application of violence. So they ought to educate their members and educate them well, because then they can be held accountable for breaches of peace Okay, so that is also very important. But that is not to say that, how do you call it, do not fight for your rights. You ought to. You ought to fight for your rights, but you ought to do so using acceptable procedures that are backed by law. To all Ghanaians, I think that this is also a period of learning for all of us. We are learning various things. And part of it is that when you decide to apply to stand for any particular position of national importance through an election, please, the lawyers are there. If you are in doubt, consult them, hire them so that they can help you to go through your process. You understand? And so, well, these are the few words of encouragement I have for not only Ghanaians but the EC. I'd encourage people to be deeply interested in reading. The problem is that sometimes the laws are there, we don't read them. Fortunately, when it comes to issues to do with elections, security, and all those ones, the books are now available. My books are there, you can look at it. Yeah.
I'll be very brief. My message would go to the judiciary, because right now we're all looking up to them, and they have assured us that they will act expeditiously. And I'm saying, okay, please, let's walk the talk. Let's act. Now we have heard you say you act fast, but let's hear you. Let's see you acting fast. Thank you.
All right, so that is it. To the public interests, we all have to be up and doing. This has been the Reporters Roundtable. We are back next week. Stay blessed.